Welcome to the Wright Family Law Divorce Podcast with your host, Ellen Wright, family law attorney, divorce coach, entrepreneur, and motivational speaker, discussing all things divorce and helping you learn to keep the pain of separation from holding you back. And now, your host, Ellen Wright.
Welcome to episode 8 of the Wright Family Law Divorce Podcast. Today, we are going to be talking about the burning question that I saw posted on a legal forum a couple months ago, which was, will I look bad if I refuse to go to mediation? I am joined with Attorney David Eppley, who is a new senior associate at our firm. David, welcome.
Oh, thank you, Ellen. I appreciate it.
You have 20 years of experience in family law.
That's right.
And what do you like best about your mediation practice?
So what I like about the mediation practice is actually having the two parties, or sometimes the parties and their counsel, just sitting around the table and hopefully coming up with a solution that can avoid all of the rigmarole in court, can avoid waiting all day to be heard. And you basically are there to see if you can settle the outstanding issues. You just have to make sure that everyone's on the same playing field and has the same information sources.
So we're going to be talking about some of the ins and outs of that, what mediation looks like in Massachusetts, because David, it's different in every state.
It is.
You go north to New Hampshire, right? Mediation is required.
Wow. Yeah.
You have to go. In Massachusetts, not so much. In terms of the way we do things, someone comes in for a divorce, David, right? And they say, we're talking about mediation. Can we mediate? Do we have to mediate? What are our options? What do you say to them?
I want to know some key things right up front. I want to know whether or not there's any kind of domestic violence in this family, whether or not there are control issues that are happening within this family. Because if one of the spouses has been in control of all of the money and has been really keeping it secret from the other spouse, mediation may not be the first step you want to take. You may want to get some more information in the form of formal discovery, and you don't have that option if it's a mediated case.
Right. So if the person says, okay, I don't think I want to mediate for whatever reason, I can't mediate right now, and this goes forward, and then as my divorce goes on, the judge finds out that I did not mediate, and I filed this divorce and I refuse to mediate, what is the judge going to think about me?
It depends. So I agree. We had some discussion about this ahead of time. I do think that you potentially could look bad if you look like you're just dragging your feet, things along that line.
Stonewalling the other party.
Exactly. Yeah. That could be a problem. So if you're perceived in that way, that's a problem. But if you have a legitimate question about a closely held business where, let's say the wife owns this closely held business, you represent the husband, and he didn't have anything to do with the business, doesn't know boo in terms of what's happening within that business. If we're just trusting what her numbers are that come back, that might not be enough for mediation. So that's why I'm saying, like, you may need to get a business valuation, for example. You may need to get a house valuation before you go to the trouble of hiring a mediator, because the purpose of the mediator is to get to yes, right, which that might be the overall goal of both parties. But sometimes before you can get to the question and answer it yes, you need some more information.
Right. What if there aren't any financial issues? What if we're just talking about a parenting plan?
Then if we're just talking about a parenting plan and there's not some significant drug or alcohol use in the family, if there's not some significant mental health or behavioral issue of either the parties or of the children, then mediation could very well be the best place to go, especially if it's someone who is highly trained, either a litigator themselves or perhaps sometimes even a psychologist can serve in this role.
Okay. All right. If I just can't stand my spouse, all right, so let's just say my husband, he never put his hands on me, but he was emotionally abusive. The name calling, the fighting, the screaming, the yelling. And let's say there aren't any sort of high substance abuse issues, but I just cannot bring myself to sit in the same room as this man. What opinions is the other lawyer going to form about me? And what is the judge going to think?
Sure. So depending upon the mediator, so you actually have two options. One would be to not go through the mediation with the explanation that, look, I, as the spouse who's kind of maybe not been physically abused, but has been emotionally abused, or maybe just has been controlled, like a controlling kind of aspect in the relationship.
Mm-hmm.
If that person feels so cowed that they're going to roll over during the mediation, then obviously the mediation is not the right route for them. But if they can't be in the same room because the temperature just goes up too much, but it's a solvable case, a good mediator actually can engage in this with a mediation session where they're essentially doing shuttle diplomacy. They're going from room to room. And I've done that as a mediator, and it can really work effectively in doing that. Again, it lowers the temperature. You can have you have a more dispassionate mediator coming in and giving the view of what the other side says and the bare facts of what they're willing to agree to. And then you go back to the other side and give them their version of what they see and what they want to get out of the mediation.
Yep. Okay. Now, what's the difference between mediation and conciliation?
So mediation is the more traditional, I'd say, the more traditional form of getting to yes, like I was talking about earlier. It's private pay. Both parties will, generally speaking, both parties will pay for half, although you could have a different arrangement if you have a more affluent spouse. Maybe they pay for 2/3, 1/3, or all of it, but it just really depends. But at any rate, you go in, that person is a neutral, and then they help settle your case. A conciliator is a court-appointed, for lack of a better term, mediator, where the case has already gone forward with some discovery. Maybe there's been a temporary orders hearing. Maybe there's been a pretrial conference. Maybe there's not been a pretrial conference. But basically, there's been some time that's passed within this case. And whether it's with counsel or without, they go to the conciliator, who again who's generally speaking, this will be if it's court-appointed, this is going to be someone that is doing it for free. So they're doing it as a favor to the bar, but you're limited to only an hour or two of this lawyer's time. They're another domestic relations attorney like we are. I've served as a conciliator before in cases in both Essex County and Middlesex County. And basically, you're there to try to help reduce the number of issues down and hopefully settle, but at least reduce the issues down so that they can go in front of the judge the next time and say, I've met with Attorney Eppley. This is what his recommendations were. We were willing to come up with this. So that's the main difference between the two.
Yeah, the last statistic I heard in Middlesex was a 70% success rate for conciliation. In your conciliation practice, is that about what you would agree?
That's probably about right.
Yeah.
I've not looked at statistics, but that sounds about right. 2/3, 3/4 of cases will settle if they've gotten to that point. Because frankly, sometimes they just need to be heard. They might have some outstanding issues, and we don't have a lot of time in front of judges when we go in front of them, for whether it's a motion hearing or even a pretrial. You have maybe 15, 20 minutes tops in order to get your point across. With a conciliator, you go to them for an hour or two. The person will have the experience in dealing with cases on both sides of the case, husband or wife, or with someone who owns a business or doesn't, someone who has custody or doesn't have custody of kids. They will have dealt with it enough, or gone before some of these same judges enough, that they can give a really good educated guess without having a dog in the fight, so to speak.
Right.
And can give you really an honest, straightforward, educated opinion where they're not taking your side, they're not taking your ex's side.
Yeah.
They're just giving and 7 times out of 10, that's probably enough to get people to say, okay, that's probably where the judge is going to come out. Let's tweak whatever agreement we have to kind of fit along with what the conciliator says or close to it.
Okay. So if it comes to the point and the judge is talking about conciliation, is the judge going to make me go to conciliation? Will I be forced? Or will I be pressured? Is my lawyer going to make me go? What if my lawyer drops me? I don't want to go and my lawyer dumps me.
Sure. No, I get it. So great question. So the judge can't force you to go to mediation, but
conciliation.
that's what I'm sorry. Thank you. Thank you for correcting me. Yes. The judge can't force you to go to conciliation, but if they're recommending it, it's probably a strong recommendation for you to do it if it makes sense. And so you need to have a good reason as to why that might not work. Maybe maybe we talked about earlier, it's too early because you don't have a valuation in, a business valuation or a home appraisal in. Or if it's a custody case, if there's a guardian ad litem that's involved and an investigation is take place, maybe that GAL report isn't in yet. And so you want to wait until that report's in before you go to the trouble of a conciliator. Because again, when you go to these conciliators, they're giving their time. You're not paying them. So they're giving their time. It's not just to you, but it's really to the court. So you don't want to waste anybody's time, but you really don't want to waste the conciliator's time, who's giving of their time. Does that answer your question?
Yeah.
Yeah.
Yeah, I think for the most part.
Yeah.
I just think a lot of people, especially in situations where there's been the emotional abuse, they cling to their freedom and self-determination. And if they feel pressured, I have to go. I know I personally have been involved in a small handful of conciliations where the atmosphere, it's just very toxic, very, very tense. And then I have a situation where the opposing side is sitting across from the table and making ugly eyes or faces at my client. In situations, like you say, breakout rooms are more appropriate out the people and do the shuttle diplomacy, like you say, to and fro. Because what you don't want to have happen is have a situation erupt and then have everything get worse than it was before they walked in.
Right.
But I think that the numbers speak for themselves, and the court really does love the conciliation because it keeps these cases out of the trajectory of a trial.
Exactly. That's exactly right. And that's in most cases, and it's probably around 70%, it does make sense to settle sooner rather than later. Once you have the necessary information, and you have two fairly reasonable, I'll use fairly reasonable people across the table from each other, conciliation is absolutely the right way to go. But again, if you've got some situations in there that there are enough of them that it's significant, but if you have a restraining order case, a domestic violence case, any significant drug and alcohol or mental health issues, those are the problematic enough cases that you're not going to necessarily come to yes sometimes. And you have to either get direction from the judge, and that's what they're there for, to kind of point you in the right direction.
Are you worried about being pressured to attend mediation or conciliation in your family court case? Don't be. Learn the ins and outs of mediation and conciliation with our free infographic download. Get it now and put your mind at ease. Click the link in the show notes to download now and be ready for whatever comes your way.
Now, what do you think about some of these conciliations that have been held by Zoom? And if there's a restraining order between the parties, what would that look like? Can you do it by Zoom? What do you think?
I'm a big believer. So Zoom is a great tool. And if you have a party that's out of state, or you have a party that maybe has some mobility issues, that is a great substitute. But a substitute is never the same thing as an in-person kind of a conciliation or a mediation. If you have let's use the domestic violence example as our example here. If you have a domestic violence case where the abused party feels comfortable enough to be either in the room with the conciliator, but the defendant is elsewhere with a Zoom call in. If that person feels comfortable that way, or vice versa, where again, the two parties aren't in the same room at the same time. If the aggrieved party feels comfortable enough, then sure, you can try it that way. I think that's a decent sort of substitute. But for, again, the vast majority of cases, if I'm the conciliator, I want people in my office so that even if we're doing shuttle diplomacy, we can see eye to eye. We can get the emotional dynamic. You can get a sense of people and what their concerns are, their wishes are, a lot easier than over technology. It's a good substitute, but it's not equal to in person, in my opinion. What about you? What do you think?
Yeah, I agree. I think that Zoom certainly has its place, right? But in terms of settling cases, just that in-person contact really is monumental.
And if you're lucky enough, Ellen, if you're able to settle the case, you can sign it right there.
Right.
Whereas if you're over Zoom, you're like, well, we'll get back to you tomorrow.
Right.
By that time, someone might get cold feet and not want to sign.
Yeah. Or the email somehow gets sent to the drafts and it gets, with the agreement. Yeah,
exactly.
I hear you. The conciliation, I think one of the really cool things about conciliation versus mediation is that in conciliation, the conciliator can say, oh, I've had cases with this judge, and here's what I think your particular judge might do. And in a lot of situations, it's enough to make people think, all right, here's someone who's with no horse in the race, so to speak, right? And they're telling me, in their experience with this particular judge, this is going to be my likely outcome. So even if they don't want to hear it from their lawyer, and they're not going to trust the other side's lawyer, what's coming out of their mouth, you hear it from a third-party neutral who has the experience. They have no allegiance to anybody, and they're just going to tell you straight up what they think is going to happen. I think that is really enough, in my opinion, to get a case to really settle versus a mediator who can't do that. They can give suggestions and guidance, but there's a fine line between where they can go in terms of giving legal advice, and it's not always clear. That's what I found is really fantastic with the conciliators.
I completely agree with you, Ellen. As a matter of, I do have a mediation practice, and I definitely enjoy it, but I will admit to you and your listeners that even with my mediations, because of my litigation experience and I guess bias, it somehow seeps into that when the mediation, because I want the parties to just get a feel for if they're really wanting to mediate instead of trying to potentially threaten each other with going to court and stuff. If we're able to work it out, fantastic. Because here's what you can expect if you go to Judge Smith or Judge Jones, right?
Yeah. So. Another situation I've seen happen, and it only really happened in one of the conciliations that I did, was the lawyers didn't get along. They hated each other. And I had one guy who was a bully. He was a bully to the woman lawyer who was on the other side, just sitting at the table, arms crossed, super grouchy. And I scolded him, like right there in front of his client. I basically told him, a lot of this is because of you. I called him right on the carpet. That particular case didn't settle. It did end up going to trial. When the lawyers can't get along, that really, that's punishing, really, to the litigants themselves.
Undoubtedly. And I think that sounds like your example that you just gave sounds to me like it might not even be the party that's stonewalling, but it's the lawyer. One of the lawyers is the stonewaller and is standing in the way. And that's not an appropriate use of the conciliation and certainly the conciliator's time. Because you were volunteering that time.
Oh, yeah. I wrote the report. I wrote the conciliator's report, sent it to the clerk about exactly what went on and the bad behavior.
Right. And just so your listeners know too, it's not, you're not reporting on about the positions that the parties had, but it was just the behavior. Yes, totally.
The behavior.
Totally.
Yeah. And I think that's another thing. People are concerned about how they're going to look if they refuse to go to conciliation, right? Okay, you don't want to go to conciliation. You give into the pressure and you finally go. And then you pull a stunt or you're on bad behavior or you don't mind your manners. And that could really come back to bite you. So people need to really put their best foot forward and represent well the conciliator, because those conciliators, some of them write reports. I do write reports if I think it's necessary. I don't write a report for everyone in the cases that I've had, but I have the ability to do that. And if someone shows up, they want to play games, and they're not going to put in any sort of a good faith effort, that could come back to bite you.
Absolutely. the other good lawyers will also know that when they're going to conciliation, that they're coming there with, I'll call it a proposed judgment, but basically it's, this is our punch list of what we want.
Right.
And being able to back it up. I've had some conciliations where either I'm one of the attorneys for one of the litigants, and the other side hasn't come prepared. So I've come with my list of what my client wants, but they haven't bothered to come up with their list. They just want to say no to what we say. And that's not an impressive.
No.
Exactly. That's not an impressive use of time or good use of time at all. And you're really going to make the conciliator mad. And I've served in the conciliator's role as well, where one or both of the sides haven't prepared what they want. Why are you spending the time doing this if you're not there to say, this is what I want? This is our custody plan. This is our asset division. This is what we want for support. Yeah. It's not that hard.
Yeah, no. It's not rocket science. Yeah. It really isn't. People have to go in with the right mindset.
Yeah.
People who do it under threat of making the judge mad, or my lawyer won't be happy with me. And if they go in with the chip on their shoulder and they don't have that right mindset to not attack the other side, you're not there to attack.
Right.
You're there to resolve.
Right.
Right. And if you go in there also with the mindset, I have to defend, am I going to be attacked? What happens if they come at me? And I think that what people need to realize is that there's a series of protections in place. When people have lawyers, obviously you've got a professional who should know how to conduct themselves and how to facilitate a beneficial dynamic that's going to help resolve the case, right? If someone is going to act up or do anything or pull any funny business, okay, you've got the conciliator, you've got two other lawyers there who will help, hopefully, curtail that before it becomes out of hand. I think in situations where you have litigants who can go to conciliation and they don't have lawyers. I've had conciliations where I've had it just with pro se litigants, and they come in and they don't really know which end is up. They've got paperwork. And I've had situations where it was a quick settle, and I've had other cases where I'm like, this is not right for conciliation. There's too much in play here. Yep. To have that buffer, the conciliator as a buffer to help bring the temperature down. You know what I mean?
Yes.
If temperatures is running hot, like you say, okay, guys, let's take a beverage break, or
and refocusing them, because if, let's say that is two pro ses, for example, and let's say that the issue really is about custody, if the dynamic that they're getting across is something about, you did this to me within our relationship, it's refocusing that discussion back to, we're not talking about the two of you, we're talking about Benjamin or Carrie, your kids, not someone else.
Right.
Not you.
Yeah.
So refocusing them back, having that professional in that role really does help to facilitate the potential of a settlement. And when you're dealing with pro ses, I kind of look at it as you're like a stand-in family service officer for the court.
Oh yeah. We're glorified social workers, really. Yeah. In that particular case where I had the two pro ses, so the parenting plan was an issue, but it also hinged on sale of the marital home. Now they could have afforded lawyers, it probably within a certain
would have been a stretch.
Scope. It would have been a stretch, but there was work to do on that. Yeah. Because the parenting plan was really predicated on how the sale of the house was going to go and the finances. Yeah. But it's tough. It can be very tough when you've got two pro ses that just come in. I had to send that one back and just say, I can't help with this.
We're not miracle workers.
No, we are not. Settle. No crystal balls, no magic wands. No, unfortunately.
That's right.
Thank you so much, David. That concludes today's episode. Thank you so much, David, for joining us. Please make sure to download our free infographic. The link to that is in the show notes. And I will look forward to seeing you guys next time. Stay well and stay safe.
Thanks for joining us today. Remember, the Wright Family Law Divorce Podcast is not legal, financial, or tax advice, nor should it be construed as such. We recommend that you consult a qualified legal or tax professional before making any decisions about any of the topics discussed in our broadcast. If you enjoyed this episode and you'd like to help support the podcast, please subscribe. To catch all the latest from the Wright Family Law Group, sign up for our email list and newsletter on our website at wrightfamilylawgroup.com. Thanks again, and we'll see you next time.